chance, but it's an uphill battle. I mean, they need to prove first that Apple is a monopolist in connection with its App Store and its requirement that you download through the App Store for the iOS devices. And then they need to prove that the requirement that you go through the App Store actually is an anti-competitive requirement as opposed to what Apple says, which is something that is necessary to protect security and privacy of its iOS users.
It does strike me, Jen, that quite a few what we would think of as tech companies have weighed in on the side, actually, of Epic Games, maybe the David in this battle, including Facebook and Microsoft is saying we find it really difficult as well. We've tried to get in, Spotify. Would that have any effect on the judge as a practical matter?
You know, I think, first of all, you know, in my mind, you have to think about the fact that Microsoft is a big competitor to Apple, you know, in many ways. They compete in the sale of computers, and they have opposing, you know, operating systems. So, you know, Microsoft has something to benefit if Epic wins this trial. And what Microsoft and some of these other tech companies are providing is really anecdotal evidence of where they do or don't compete, and the difficulties that they've also had in negotiating with Apple to get their own game stores or their own game streaming into the Apple App Store. So it's anecdotal evidence, you know, and at the end of the day, I think it has some influence, but not significant.
Jennifer, there's been a lot of debate about whether we should be focused on the consumer. Is the consumer hurt or helped by whatever is going on in the marketplace? Here, I guess that Epic Games has a real claim that you'd be better off if you're a Fortnite user, because part of what I think got into trouble was offering a discount on some of the upgrades that were awful, or if you don't do it through the App Store.
You know, I think that the consumer question is a really interesting one here, because you know, what Epic will say is that Apple's policies are driving up prices, that consumers, hey, this is getting passed on to you. And if developers have to pay this big fee to Apple, you know, this is just all going to cost more for you to play these games. But on the other hand, Apple is saying what we're providing consumers who really want it is extra privacy, security, reliability, and that this is really important to our consumers who are willing to pay a premium. So, you know, the consumer welfare side of this and how this is playing out, I think is going to be a very, very interesting aspect. I think, and the other thing, though, David, that's been coming out in trial that's interesting is that Apple has not stopped consumers from buying these games or buying the V-Bucks that you buy when you play Fortnite to use within the games at a discount if they buy them through the web, through that company's website. And then if they pass through over to the iOS, and you can then use those dollars in the iOS, and you can use that game, and Apple took nothing. Apple is doing nothing to stop that. Apple is doing what's called anti-steering, where within their own app store, those companies can't advertise that you can buy these cheaper outside the app store. But the fact is that you can, and the fact is that consumers do.
Yeah, so there may be a way around it, albeit maybe more difficult. Bill, this is not the only issue that big tech has on its antitrust platter right now. We have various government, both federal and state level actions involving, for example, Facebook and Google. Does what goes on between Epic Games and Apple have any ramifications for all the rest of the enforcement actions?
I think so. This outcome, which will obviously be appealed, whatever the district court judge decides, is similar in many respects, this case, to the government's challenge to the behavior of Google and of Facebook. We've seen over the years a very conservative Chicago school approach to claims of monopolization. Not many have been upheld. 20 years ago, the Microsoft monopolization case was the last really big one where a plaintiff prevailed. So this thing has real implications, both for what courts are going to do down the road and for the debate in Congress about whether or not we need to change the 1890 Sherman Act.
So, Jennifer, that's a really interesting point that Bill makes. One wonders whether big tech could win this battle involving Epic, but actually lose the war if, in fact, it increases the chance that Congress might act.
No, I think there's a serious chance of that. I mean, Congress is really cognizant of the fact that the way the antitrust laws have developed over time has made it very difficult for a plaintiff to win a monopolization case in court, and that the judges have tended to be cautious and business friendly in their decisions. And I think every single time you see another decision that comes out that way, it's just going to add fuel to the fire to those politicians that do believe we need to change the laws and we need to make it easier for these plaintiffs to win monopolization cases. I mean, you saw it with FTC v. Qualcomm. Right, where the FTC, I think, did a great job in trial, had great evidence really supporting it, but lost, and then lost again on appeal. You know, you have that to start out. You have the AT&T Time Warner, you have the Sprint T-Mobile trial as well. So, you know, we're looking at this history of these cases where the government's been losing, and the politicians are really well aware of that. And what they're really seeking to do, particularly Amy Klobuchar in her bills, is to overrule some of the Supreme Court precedent that has set up these hurdles.
Bill, as you know so well, a lot of businessmen just say, just give us the rules. We just want to know what the rules are. And we have known for a long time, we think what the antitrust rules are. Under, as you call it, the Chicago School, there's a developed body of doctrine and law there. Is anybody come up with an alternative to that? I understand people don't like the way it's going now. They'd like more regulation in some sort of big tech. But what's the alternative, and how can a business person or an investor plan for that world?
Well, I think that's an entirely fair question. And you know, the Chicago School approach has been to look narrowly at impact from behavior or a merger on price, to the exclusion of product quality and innovation. And I think some of the advocates for reform are simply saying we need to look at the overall impact on competition and consumers, and not necessarily require a showing that there was a price impact.
Some people are saying part of the problem here with concentration in big tech is the political power they have. How do you measure that?
I think it's impossible to measure it, but obviously when you see that Facebook or let's say Twitter have the ability to sort of direct conversation or even to shut down conversation, I mean, you begin to see it manifest in those ways. And right now we have this whole issue with Facebook, you know, and having banned the former President Trump from Facebook, and now looking at that decision again and deciding to keep him off Facebook. There is an issue with the fact that you have companies in corporate America that might be able to control the message. So it's one way that political power manifests itself. And I think that's a really difficult question and a difficult thing to grapple with, because in my mind, the answer to that would be simply making these companies smaller or breaking them up. And I don't see that happening either through court or through legislation.